In 1963, Ernesto Miranda was arrested and interrogated for 2 hours regarding a suspected kidnapping and rape. At the conclusion of the interrogation, the Arizona State Police had obtained a written confession by Miranda that was admitted into evidence at trial, where Miranda was found guilty.
Warning. The following scenes are a dramatic recreation of the real events that took place surrounding Ernesto Miranda's trial. Some embellishments may or may not have been added.
Well, golly gee, officer, what seems to be the problem?
You's has been under arrest, Mr. Miranda.
Oh, why, what for?
Because you've been raping people. Now get on the floor, you filthy ignorant.
Well, I'll be.
Now let's go. Mush, you filthy ignorant. Now just hold on a minute. Now sit down over there. We can do this the easy way or the hard way. So why don't you just make my job easy?
Well, I ain't done it.
Well, we're gonna be here for a long time. Now for the final time, Miranda, just tell me you did and I won't have to send you down to the slammer and get me out.
Well, I don't want to go there. I'll sign whatever you got.
Now wasn't that easy?
Now, hold on, folks. I know it may seem as though justice has prevailed, but a key element of our civil liberties has been ignored during these proceedings. The rights to counsel and to remain silent are derived from the self-incrimination clause of the Fifth Amendment. In Miranda v. Arizona, the arresting officer failed to inform Ernesto Miranda of his legal rights prior to his confession, and, as such, his lawyer, Alvin Moore, argued that his voluntary confession was not admissible in a court of law.
Chief Justice Earl Warren will now deliver the opinion of the court.
Due to the coercive nature of the custodial interrogation by police, no confession could be admissible under the Fifth Amendment self-incrimination clause and the Sixth Amendment right to an attorney unless the suspect had been made aware of his rights and the suspect had then waived them.
Though this may have been a joyous moment, Miranda went on to be retried without the court system's use of the confession as evidence. He was then convicted to 20 to 30 years in prison. He got off early on parole, but later died via a knife wound in a bar fight.
The rise of the legal aid movement in the 1960s led to an increased national interest regarding Miranda v. Arizona.
Escobedo v. Illinois, which foreshadowed Miranda, had brought the issue of corrupt police interrogation tactics to the forefront of the country's legal minds. The litigants in this case were Ernesto Miranda and the state of Arizona. Miranda's lawyers were the court-appointed Alvin Moore and then John J. Flynn and John P. Frank once the case was brought before the Supreme Court. Leading the charge for Arizona was Assistant Attorney General Gary K. Nelson and Attorney General Darrell F. Smith. Since the landmark case of 1966, Miranda v. Arizona has been modified through updated rulings. For example, 1971's Harris v. New York established that confessions may be used as proof of inconsistency in a witness's story. 1980's Rhode Island v. Innis ruled that spontaneous statements are admissible in court so long as they are not in response to police questioning. In 1984, New York v. Quarles established a public safety exception if there is information about an imminent danger that the person being interrogated can provide. Finally, the 2010 decision of Burgess v. Tompkins states that if a suspect exercises his right to silence in an ambiguous or equivocal manner, the interrogation does not need to cease. Some scholars have claimed that this ruling has effectively gutted Miranda v. Arizona.
This court case has had a huge impact on society. Now it is established that police officers have to read arrestees their rights and must have proper interrogation proceedings. Whenever someone is arrested now, you will hear their rights being recited to them. Also, many people are now aware of their rights due to the popularization of these Miranda rights in things like Law and Order, Cops, shows like that. With the ability to have legal counsel provided, many prisoners' cases likely ended up very differently than if they had just represented themselves. Now here's our opinion on the court case. Like many other Americans, I was also under the impression that if a police officer did not read someone their rights, they could be let off without punishment. While this is not the case, we still see the power and importance this decision had. We support this decision because if we were ever in a situation like Miranda or one of the other cases we mentioned, we would like to know what rights we have, and we would also like to have the amazing ability to not have to self-incriminate